Good morning, everybody. It is Sunday, November 6th, before probably one of the most historic elections that we'll ever see in our lifetime. And I wanted to bring the third part. I know there's already going to be a fourth part just because I have so much just to talk about in just a very short period of American history, basically 100 years. As I left you with the second part, I discussed why our founding fathers came here. And I think that this is significant, and I've done a lot of research to bring you. I think that this is significant to bring this to you before the election because you'll understand really what you're voting for, which is not a lawful government. So let's get to it because there's a lot to talk about. Okay, what I'm going to discuss now is the periods between the founding of our government and basically just a little after the Civil War. And I wanted to first talk about, as you know, the significance of our foundations of our government was that it created a fourth branch of government in the fourth crown, the fourth branch being the people, which is not spoken about in the Constitution, but it has been brought up. I believe Scalia spoke about the fourth branch of government. The fourth branch of government really is the first branch of government because we found the government. But they like to call it the fourth because we're the fourth crown as well. So the fourth branch of government with the fourth crown is the power of the man to affect, and woman, to affect law as he sees from his nomenon that law should be. So direct line from God, what you know to be right. And prior to that, there were people who were between you and God, the king, the pope, a variety of people. But there's also, this is a little list here. This is from the Laws of England in 4 books, Sir William Blackstone. This was published in 1868. And this actually speaks to the table of precedences. And that is on page 404 in chapter 12 of persons. That's section 404. It's actually on page 313. And it speaks to the table of precedences because this is actually the list of titles of nobility. And it starts at the top with the king, and then the king's children. Then you go down to dukes and earls and marks and viscounts. Then you have privy of counselors, counselors. Then you have chancellors. Then you go down here to knights. Then you have sergeants at law, doctors, esquires. Esquires are down here, see? Esquires are below doctors and above gentlemen. And above yeomen, tradesmen, artificers, and laborers. And then married widows and women are below that. But this is the title list. This is the titles of nobility that our founding fathers did not believe were allowed or there by the will of God to be between you and the law and what you know to be right. So when we speak about titles of nobility, we are talking about everybody listed, okay, that is of a particular class and title, which is inclusive of esquires and doctors. And by the way, doctors is often spelled D-O-K-T-O-R. That's just an alternative thing. It's spelled differently. It's spelled D-O-C here, but there's times that people do spell D-O-K. So this is the ranks of the titles of nobility. They were given to people by the king, and then the king was given his title by the pope, really. So and or the people, but he was affirmed by the pope, and so it was considered a title of nobility. So when we speak of that, we're speaking about those people who were given titles under the table of precedences that Sir William Blackstone brought to and has put in paperwork and in a book so that we can reference that. Now, we know of the founding of our country, okay, and we know that that we had a civil war, and the significance of that, and I have quite a bit of evidence here, is that after the Civil War, we signed what's called the Definitive Treaty of Peace, okay? And it was signed on September 3rd, 1783. And the significance of me bringing this, it's called the Definitive Treaty of Peace, and it's between the United States and His Britannic Majesty. Now, this information that I have here can be found in the Public Statutes at Large of the United States, volume 8 in Boston, 1867, and it's copious notes on the decisions of the courts of the United States, etc., etc. Now, I got this from the Ohio State Library. Excuse me. The collection of the State Library of Ohio, not to be confused with the Ohio State Library, which is a university. So this is the State Library of Ohio. Completely different. Notice the words. So the significance of that is the beginning paragraph, and I want to read just a little bit of this to you. In the name of the most holy and undivided Trinity, meaning up there, in having pleased the divine providence to dispose the hearts of most serene and most potent Prince George III, by the grace of God, King of Britain, France, and Ireland, defender of the faith, Duke of Brunswick and Lunenburg, Arch-Treasurer and Prince Elector of the Holy Roman Empire, okay, and the United States of America, mixed uppercase, lowercase of capitalization, United States of America. Notice he is the treasurer of the Holy Roman Empire. Gosh, imagine that. So he's the prince-elect, meaning, because the king is the king of the Holy Roman Empire is the Pope, but he's the prince-elect of the Holy Roman Empire. So you say right there, we have a treaty with the Holy Roman Empire. Remember how I've told you that the Holy Roman Empire is just Rome, okay? So there's the significance of that. So we get, and we have this treaty with them as the United States of America. Well, lo and behold, we start going around and we start having issues with sedition. And this can start to be seen particularly in the, and they had what's titled as is suffers under the sedition law. Now, this particular document is in the debates and proceedings in the Congress of the United States, important papers and public documents. It's the 11th Congress, 1st and 2nd section. I suggest anyone who really likes history go read this because it's full of stuff. And this was published in 1853. Now, the significance of this is on section. The way they have these is they'll have 119, 120. So they really have columns. So this is 120. And it's under sedition law. And it says, this is the resolution. It says that the committee appointed to inquire into what prosecutions for libel at common law, notice common law. So the point of the sedition laws was to address violations of common law, okay, have been instituted before the courts of the United States, be instructed to inquire what prosecutions for libels have been instituted before the courts of the United States under the 2nd section of the act entitled, an act in addition to an act entitled, an act for the punishment of certain crimes against the United States passed on 14th day, July 1798, and the expediency of remunerating, I'm sure it means to provide remedy and relief to sufferers under such prosecutions. So, starting as soon as we had, this treaty, we start having problems with sedition and treason, mostly because people are still British subjects, okay? They're British. We're kind of mixed in here. Some of us, decide to just be here, but there's really no formal statement of what people should do other than the fact that the Constitution had said that you're not supposed to be taking emoluments. This was within the full body of the Constitution. So up comes the 13th Amendment, titles of nobility. And because they had had such extreme problems with sedition, particularly with people within the government doing things against the government that were in violation of the common law. Again, the significance of this is to show you that the Sedition Acts were about common law violations. Now, and that tells you that the Titles of Nobility Act is about common law violations. Okay, that's what it's there to rectify, is the common law violations. So I'm going to go real quickly over the facts of the 13th Amendment as I brought them in my writ of conspiracy. This is just the 13 pages. The supplement with the supplements, it's about 1.5 inches. So I'm going to go over some basic things here for those who have not read my writ of conspiracy, okay? So I talk about that. One, I cite the Titles of Nobility, the table of precedents, expressly showing that esquires and doctors are in that precedence of titles of nobility. Okay. So then I talk about how in the debates of Congress of 1789 to 1791, they speak about Article 1, Section 9, Clause 8 of the Constitution, which states, as I said, taking emoluments from foreign powers was already in the body of the Constitution that was ratified by the people. And still you had people within the government and within the United States violating this, which was a general principle of the Constitution that everyone had affirmed. It says that, so Article 1, Section 9, Clause 8 says that no title of shabbility shall be granted by the United States, and no person holding any office or trust under them shall, without the consent of Congress, accept of any present emolument, office, or title, or any kind whatsoever from a king, prince, or foreign state. Well, there were people going around that were members of the bar in Britain, running around the United States, doing stuff that were in positions of power or trust, specifically at that time with the private banks and the private treasury. Okay, so most people don't understand that the United States started with a private trust and a private treasury, as far as I know. I know that at least until the 1840s, there was a private trust and a private treasury, because I'm going to speak to that. So it's already in the body of the Constitution that these people are not supposed to be doing the things that they're doing. Okay. So, according to this, after we talk about the sedition laws, and again the continued acts of sedition, that on April 27, 1810, that the Senate read for the third time and passed the resolution respecting the titles of nobility clause, as we know it. Okay? Then on May 1st, 1810, the House passes this. And the vote on the Senate was 19 yeas and 5 nays. So that was on April 27, 1810. The Senate, quote, of the United States of America in Congress assembled, not the Congress, the United States of America in Congress assembled, passed the titles of nobility by 19 to 5. Then on May 10th, the House of Representatives of the United States in Congress assembled, passed it, and thereby by 2/3, okay, and there was 87 yeas and 3 nays in that one. So it was pretty overwhelming support for this document. Now, if you read the history, it's because something had happened. There was a boat that was taking merchandise to be sold overseas that was under the flag of the United States Trading Company, and was traveling, and Britain attacked it and killed most of the people, sunk it, and the United States sent an emissary over to England, and this was around this time, prior to this happening. This event is what precipitated them actually codifying, though it was already in the Constitution, codifying a particular amendment that made it resoundingly clear what would happen if you were working underneath or for the purposes of a foreign power. So they sent an emissary after this boat had been basically keeled and sunk and killed most of the men on it, and they sent an emissary to Great Britain and said, you need to pay us for the lives of the men, pay for the wrongdoing and the merchandise. The emissary was met by an emissary of the Queen, who said, not only are you not even legitimate enough to talk to me, you certainly aren't legitimate enough to talk to the Queen. You and your president isn't either. So they kind of insulted the whole of the United States. So they basically sunk one of our ships, killed a lot of our men, and we're supposed to be under a treaty of peace and amity. Okay, this after 1776. We're supposed to be under a treaty of peace. Okay, so that was a violation of the treaty of peace. 1. So this emissary comes back with this purported statement of, their opinion of that we are unworthy to even speak to, even though we have a treaty with them. And the Senates and the House are in uproar. They're offended. They are morally offended. They think it's a slight to the United States and actually a moral offense to the president. So they go about passing this amendment. So as of May 1st, 1810, both houses had passed by 2/3 of a vote the ratification for a 13th Amendment called the Titles of Nobility Amendment, and it reads this: If any citizen of the United States shall claim, receive, or retain any title of nobility or honor, or shall, without the consent of Congress, accept or retain and present pension, office, or emolument of any kind whatever, from any person, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them, or either of them. Okay? So they passed it. Now, as of that time, it was done, right? It was ratified. Well, everybody got a little mad. All the attorneys got mad. England got mad because basically the title of nobility divided the United States, title of nobility amendment, divided the colonies from all the other forms of law that existed, the other three crowns. It divided us from papal, Roman, and monarchical law and said, all you people who get titles from the Pope or the kings, you're not citizens of this republic. You are foreign. That is the significance of the title of nobility, is it separates what is foreign and what is not within, again, the common law, because the sedition acts were for violations of the common law. We're not even going to talk about the violations of equity that these people were doing. I'm going to bring some of them up. So the Constitution of the, this particular amendment is discussed and brought forth in a variety of places. And I'll bring this book up. This is actually a book called The Constitution of the United States of America, annotated. Okay. And this was actually published in 1938 under an act of Congress, 7th Congress, 2nd section, document number 232. Again, these are, when I go do research, I pull state papers. I don't go and get stuff off the internet. I actually go either buy the book or I go get the book and have it stamped, or I copy the book, in the library and have it stamped as a certified copy. So these are all thoroughly historical documented facts. And you can go look at everything that I say in this particular video to prove what I'm saying. So everyone was mad, right? Britain was mad because we've made it so that their little agents can't come in here and steal our stuff anymore. So Britain started a war, the War of 1812. Now, in the meantime, you'll notice that, and I'll go back to this, my writ of conspiracy possibly later, but so they start the War of 1812. And the one thing that most people who are particularly from the regions that were actually colonies and or states at the time of the War of 1812, is they know that they went around and burned all the courthouses. And the significance of that, as I've spoken before, is that the courthouses were armories. They were the safekeeping. A lot of important documents. They were where you would register your titles, your lodial titles, your important documents. If you were concerned about them being safe in your possession, you would definitely have to, and a lot of them had to be registered with the county in order for them to be properly documented as titles. Okay, so the War of 1812 happens, right? And the whole point of the War of 1812 was to literally obscure and try to hide the passage of the 13th Amendment. They went around and burned all the county seats. They also wanted to destroy all the lodial titles or possess them. And there's a lot of belief that before they burned them, you know how you go and criminals they'll rob you and then they'll burn your house so that you don't know what's missing. Well, that's kind of what the British did. So the British came in and basically stole all the instruments and burned all the county courthouses. So the United States of America had a lot of it, and the counties had been routed and had a lot of their instruments stolen and or burned after the passage of the 13th Amendment. That was the point of the War of 1812, was to obscure the evidence and things like that, and also to rout out the lodial titles and all of the paperwork that the United States sovereign communities and the counties had developed. So along comes what we call the Treaty of Peace and Amity. Now, the significance of this is it's between His Britannic Majesty and, again, the United States of America is the title. But there's a parsing of language in the first paragraph. This was passed December 24th, 1814, ratified and confirmed with the advice and consent of the Senate February 17th, 1815. So again, it's a ratified treaty. And this is called, and I'll read again, just the basics here, the very first paragraph. So, His Britannic Majesty and the United States of America, notice he says, United States of America, desirous of terminating the war which has unhappily subsisted between the two countries, and of restoring upon principles of perfect reciprocity, peace, friendship, and good understanding between them, have for the purpose appointed their respective plenipotentiaries. That means their appointments. That is to say, His Britannic Majesty, on his part, has appointed the Right Honorable James Lord Gambier, late Admiral of the White, now Admiral of the Red Squadron of His Majesty's Fleet, Henry Goulburn, Esquire, a member of the Imperial Parliament and Under Secretary of State, and William Adam, Esquire, Doctor of Civil Laws. And the President of the United States, not the President of the United States of America, by and with the advice and consent of the Senate thereof, have appointed John Quincy Adams, James Bayard, Henry Clay, Jonathan Russell, and Albert Galland, citizens of the United States, who, after a reciprocal communication of their respective powers, have agreed upon the following. And then it goes down and says, there shall be a firm and universal peace between His Britannic Majesty and the United States. Now, the first article says that there's a universal peace between His Britannic Majesty and the United States. Yet the first paragraph, the first sentence of the paragraph says, His Britannic Majesty and the United States of America. Now, why would they have such a parsing of such things, right? Well, that's because they're two separate instruments. And that's the thing that people need to really understand, is that these are separate instruments. The United States of America is not the United States. And they are clearly distinguished in treaties. In this particular case, what this is telling you is he made a treaty with the Joint Stock Trust Company, which at that time was privately run by probably esquires. But it was supposed to be on the benefit of all the colonies and the county sovereigns bringing forth materials. Because remember, the purpose of the federal system is for commerce. And so you have the main body of law, the organic instrument of law, and commerce. And the commerce is supposed to be done within the morality of that instrument. So that's the significance there. So let's skip. Oh, sorry. Let's maybe go back to the 13th real quick, because I think that this is important. Only because you'll notice that the individual who is named in that particular instrument is John Quincy Adams. Okay, he is considered a citizen of the United States. Well, John Quincy Adams also happens to be the Secretary of State when the title of nobilities amendment is suddenly just forgotten, because he brings forth on the after this, he brings forth, pursuant to the Annals of Congress, published on 1854 in February, according to February 6, 1818, a message from the President of the United States, again, not the United States of America, James Monroe, a member of the British Bar and Esquire, transmitted a report. Now, mind you, according to the titles of nobility, this guy's not even supposed to be president, but he's president of the corporation. Okay? So he transmits a report, or he receives transmitting a report from the Secretary of State, John Quincy Adams, a British Bar member and Esquire, in compliance with the resolution, where he shows that and he places upon the bar in the House of Representatives that the Tona Amendment shows 15 of the 17 states have reportedly approved the 13th Amendment. Okay? And he lists all of them. He lists Maryland, Kentucky, Ohio, Delaware, Pennsylvania, New Jersey, Vermont, Tennessee, Georgia, North Carolina, Massachusetts, New Hampshire, and Rhode Island, all approved. You notice he doesn't even mention, and then he goes on to say that with New York, this is specific, this is important, because he goes on to say, New York has disapproved the amendment, and 3 states, Connecticut, South Carolina, and Virginia, reportedly have not provided documentation. But he doesn't say that. Okay, in this, he doesn't say where's Virginia. He just says that they haven't. That, in fact, I specifically believe that he only mentions New York, Connecticut, and South Carolina. Uh, so you have them very integrated. And we may find out in the end that John Quincy Adams is not such a nice guy and was actually a traitor to the United States. So now we're going to move to 1841 because, you know, everything's waters under the bridge. We had a little war and now we have a treaty of peace. Now we're all citizens of the United States. And we're still running around with esquires running the government, even though the titles of nobility, which squarely says, according to the king's precedent, they shouldn't have been in the government. Now, mind you, it was passed by people in the Congress. So likelihood is that the executive branch and all these private treasuries and stuff were being run by the esquires, and legislatures being run by the people. So the people said, hey, you're not allowed. You're being seditious. You're creating crimes against the common law. We're going to pass this. Here's the law, and then all hell broke loose. And now everything's fine. So it's fine until 1841. Okay, and this is from the Congressional Globe. Sketches of the debates and proceedings of the 26th Congress, Second Session, Volume 9. And this is published in 1841. 1841 is when it gets a little hinky, and you start seeing some stuff in the Congressional Record about the coup of the United States. Okay, so let me just, this is a 3-page document, and it's very lengthy, okay? But this is the foundation right here of the Civil War and why the Civil War was brought into fruition. And that's because the newly elected president at the time had just brought forth a statement of, and I believe this is in December of 1840 is when this actual particular, December 9th, see, yeah, I think it's December 9th, 1837, sorry, is when this is brought. And there's been, the Committee of Finance has brought a statement to Congress about the state of affairs. And they talk about how they're multi-million dollars in debt. And this gentleman, Mr. Webster, it could be the Webster for all I know, because he was an attorney, starts speaking about the problems with this. And he specifically talks about how there are trusts, okay, that have been misappropriated by the Treasury. Again, at this point in time, they were a private treasury and a private bank. And he says specifically, he observed that there are premium paid on these stocks because they're talking about state stocks. And what most people don't understand is when they went into the territories, because this is a trading company, that's what we are. The United States is the trading company part. They went into, and then the colonies were formed by the overlaying corporate regions of the territories. So the state Ohio, though it is a republic, because it has a legislature, if it's de jure, also has a joint state stock company called, it's a bank, okay? Those stock companies would go in and create trusts with the regional native tribes, and they would say, hey, we know you own all the land. Do you want it all? Can we buy some of it? We can't pay for it outright. So what we'll do is we'll put it in trust and we'll create a trust for you. And then as people come and want to buy the land from us, we'll give them tenant rights, not land rights, just tenancy rights for the top of the land. And you will retain the first lien. And so the states all went and did this, and even the territories, the Missouri Territory, before it was, all these did this. And they went and they created trusts for these native tribes. And then and those trusts were supposed to be set aside, and they were held by the federal instrument, okay, because treaties, they were done with treaties. So the federal government held the treaties of the native tribes that the states had brought forth and said, hey, here's the natives, we're going to, and we'll be the keepers of this. We're going to take the money from the natives when we sell, or excuse me, we're going to take the money from the lands when we sell tenement rights, and we're going to send the money to you, and you're supposed to keep it in trust for the natives, and it's supposed to be their possession and theirs to keep, okay? And it talks about this in here, that the point of the trust. But he goes on to say that he observed that there was a premium paid of these stocks of $47 million. $47 million in silver is a lot of money back then. Okay, $441,076. I'm trying to think if that's 47,000. It may be. Either case, 47,000, 47, comma, 441. I don't see a period, but it must be cents. There's a space. But he observed that the Indian, Kentucky, and New York stocks were purchased at a discount of 0.5%. Alabama and Arkansas stocks were purchased on par. Missouri stock purchased 3, blah, blah, blah. They found, down a little bit, they found also that they were invested in state stocks up to April of 1838 for the Choctaw by the Treasury Department, the sum of, and this is 1,994,141, the premium paid the stock. But what he does talk about is that these funds are misappropriated, that they were put into the general fund. Okay. It says right here, now it appeared that instead of keeping separate accounts on this trust fund, the proceeds of these sales were all passed into the general receipts and accounts of the Treasury, and that expenditures of the purchase of the stock for the purpose of this investment was charged on the other side of the account. So they misappropriated in the private treasury and bank all the money that the states had been sending to the federal government to the tune of multi-millions of dollars and to the general fund, and it offset the wrong side of the ledger. So the states who'd made payments were being held liable for payments they'd already made. And the fact that the president at the time, or in the statement made by this accountant, that they were $7 million in debt. And so this Mr. Webster is like, how is it that we are $7 million in debt? And he affirms that up until this point, the United States was totally flush. Okay. He's like, how is it that we're $7 million in debt? You misappropriate all these millions of dollars of native funds, trust, and we're still in debt. Because he's like, okay, so you had extra millions of dollars in the fund, and then you spent this $7 million that now we're in the negative. Where before, we weren't in the negative. So he's like, what's the deal? Because he's basically bringing up embezzlement. He's bringing up charges of embezzlement by the private United States Treasury and the private Bank of the United States. So that's the first hint that the states are being stolen from by these people in the federal government, again, who act like the 13th Amendment doesn't exist. They've been trying to obfuscate it. They, at this point in time, have started, even though it was in, documentation, published laws, and even being taught in some schools, there are primers for school that say the 13th Amendment was passed. And yet there's still esquires running around stealing money from the Treasury, or from the joint stock trust, misappropriating funds and disappearing them somehow, and all these things that these attorneys are doing, these esquires for the bar, Britain. So there's trouble a rumbling, because they're saying there's multiple millions of dollars missing, and we're talking silver dollars, not talking paper dollars. What people understand is that the states would have commerce, paper commerce, but those were from their trust stock company, their trust companies, their state stock companies. So each state had a stock company that kind of held the wealth of the state in trust. So now we start seeing some crazy things happening, and this is the first thing that I wanted to talk to you about, because I find it very interesting. So we start to get to, this is 1848. There's a couple things that I want to bring up here. Where does it go? The United States had sedition and treason just rampant. And a variety of statutes started to be passed in the federal Congress. They say it's a Congress assembled, but when you have attorneys running around in there, and you have attorneys running the government, you're already de facto. It became de facto after 1812 because you had attorneys in there making treaties, which the 13th Amendment clearly says you can't do. You can't be in there, dude. You're taking a title of nobility. So that from that point on, everything that they're doing here is suspect and is probably for the purposes of the coup, and that will become very clear. Now, what I'm working out of here are the public statutes at large. And this is copious notes of the decisions of the courts of the United States, indexing yada yada. This is volume 5, 1848. And it says the organization of the government in 1789 to March 3rd, 1845. Now there's some specific acts I want to bring forth that are federal statutes. Okay, this says an act of the 28th Congress of the United States. This is Statute 2, Chapter 2. Okay. And, sorry, I'm going to do Chapter 1 first, because this is very relevant to what's getting ready to happen on Tuesday. This is the first, one of the very first undermining things they did with the constructs of the states. And this is Statute 2, Chapter 1. An act to establish a uniform time for holding elections for electors of president and the vice president of all states of the Union. Now, most people don't know that what we used to do is the people, the legislature, the people, the fourth branch in the fourth crown, used to elect the electors. Okay? So what you have to do is think about everything they're doing now is setting up for a coup, a final coup de coup, okay? The final coup of the states, because they've already couped the federal instrument with the War of 1812 and the treaties and all that stuff, and the attorneys still were running around stealing money. So, from the states and the federal treasury, even though it was privately run in the federal bank, they were just stealing millions of dollars, and they were stealing the trusts of the native tribes, who, by the way, all have lodial title rights. They are the first lien on all these lands. So anybody who doesn't understand that, about that the native tribes that were here hold lodial title to the lands, and I can show you extensively how they undermine that, but I'm going to bring these points first. So Chapter 1, an act establishes. So it says, be it enacted. And remember, we used to elect them. Okay, we, the people, used to elect the electors. They weren't appointed by private, imaginary people. At this point in time, attorneys do it. Okay, it says, be it enacted by Senate and House of Representatives of the United States of America in Congress assembled, that's the law body, that the electors of president and vice president shall be appointed in each state on the Tuesday next after the first Monday in the month of November of the year in which they are to be appointed. Okay, so we went from electing to appointed. Provided that each state may, by law, provide for the filling of any vacancies or vacancies which may occur in the College of Electors when such college meets to give its electoral vote. And provided also when any state shall have held an election for the purpose of choosing electors and shall fail to make a choice on the day aforesaid, then the electors may be appointed on a subsequent date in each manner as the state shall provide by law. So basically what they did is they said, hey, if you guys can't hold an election, we're just going to let the state appoint them. And the state is an amorphous thing here. It's a big S. It could be corporate or whatever. So basically this act takes away the power of the people to elect the electors, which are a proxy vote for vice president and president. We've never directly voted for the president and vice president. We always had proxy votes in electors, but we used to actually elect the electors. This statute undermines that construct and says, hey, if ever you can't have an election, the state can appoint them. And the state being an amorphous entity, okay? Another thing that I think is very significant, and for me, and I just want to bring this up for other people to investigate if they want to, is Chapter 2, which says, an act to correct a clerical error on the act supplementing an act to regulate arrest on men's process in District of Columbia and to amend the title thereof. And the reason why it's because it's arrest on men's in District of Columbia. Now, this says that no one shall be arrested for fines over $500. But if they are arrested, and I'll read it to you, that the act entitled men's be approved. And what they're talking about in the Men's Act is that people who had debts for less than $5 could not be arrested, that they could then be bonded out. So it speaks specifically to some of the activities that follow the Civil War in the Bankruptcy Acts of 1898. Now, the other thing that they also do is they amend the jurisdictions of the district courts of the United States. Okay, now notice it says district courts of the United States, not the United States district courts, which is what they're called now. This is specifically act supplementing an act to repeal an act for better organization of the district courts of the United States within the state of Louisiana. They also do a bunch of extensions. It says an act extending the jurisdiction. Now, to me, when you read this act, it's not an extension, it's an expansion. It says extending the jurisdiction of district courts to certain cases upon the lakes and navigable waters connecting the same. When you read it, though, it's really not. Because it says, in all suits brought in such courts as such manner of contract or tort. Now, tort is a law. It's a common law thing. The remedies and the forms and processes, the modes of proceedings shall be the same as are or may be used by such courts in cases of admiralty and maritime jurisdiction. The maritime law of the United States, so far as the same is or may be applicable thereof, shall constitute the rule of decisions in such suits in a manner to the same extent and with the same equities, and is now as it now does in cases of admiralty and maritime jurisdiction, saving, however, to the parties the right of trial by jury of all facts. So basically, they're kind of combining law and admiralty. So to me, that's not extension. That's utter expansion. And that's one of the very first acts that they did that with. Okay? So we now come to some things, more of these. Okay. Now we have more treaties at law, more statutes at large and treaties. A whole section here, a lot of tabs. And these are all specific acts that undermine the sovereignty of the states and the people in their federal instruments. One of the first things that gets done is we go around, and these are acts that happen just prior to the rebellion, okay? And I have these in historical order, so hopefully they'll make sense to you. The next thing that happens is the United States, again, this is very interesting. This actually is in the documented history of the Constitution of the United States of America, Volume 2, which I own. 1780 to 1870. And what it brings forth is the second 13th Amendment. Now, mind you, they've obfuscated the first 13th tone at this point in time, and they bring forth another one. Now, this was presented by joint resolution on March 2nd, 1861. Okay? And it says, this is the exact language, this is House Resolution 80, received 5th of March, Public Resolution 7, 36th Congress of the United States. Notice it doesn't say in Congress assembled. It does down here eventually, but they kind of mix the two. In the second session, begun and held in the city of Washington in the District of Columbia on Monday, the 3rd day of December 1860. Joint resolution to amend the Constitution of the United States. So mind you, there's already 13th Amendment, but it says, resolved by the Senate and House of Representatives of the United States of America in Congress assembled. Now they run around saying they're the law body, even though there's attorneys in here, and the 13th Amendment, what we know historically, was ratified, but they're trying to pretend like it wasn't, that all these documents were just lost. Okay, that the following article be proposed to the legislatures of the several states as an amendment to the Constitution of the United States, which, when ratified by 3/4 of the said legislatures, shall be valid to all intents and purposes as part of the Constitution, viz. Article 13. No amendment shall be made to the Constitution which will authorize or give Congress the power to abolish or interfere within any state with the domestic institutions thereof, including that of persons held to labor or service by the laws of the state. Now, this was approved March 2nd, 1861. James Buchanan was the president, I believe. Yes. And so the clerk is verifying that this got passed on March 2nd, 1861. Now, this amendment is noted in this book here, the Constitution the Constitution of the United States annotated. And this is, as I said, a Senate document. And I believe there's only 500 of those. I have like 2 copies. So either they don't care, or God gives me 2 copies of everything. So in this annotated book, it speaks of both the first title nobility amendment and the second one, as it speaks about the one that we all know, which says, Section 1, neither slavery nor involuntary servitude, except as a punishment for crime, wherever the party shall have been duly convicted, shall exist within the United States, and any part subject to their jurisdiction. 2, Congress shall have the power to enforce this article. Now, you will notice that there's no clause in any amendment in the Constitution that talks about Congress having the capacity to enforce or power or modify amendment. That never existed until you get to the statutory de facto Constitution and the de facto government, quote unquote, of the states and feds after Civil War. Everything after the Civil War, most of them say, and Congress shall amend, and Congress has the power, because it's a specifically all statutory Constitution versus the one before that, which is law. Big L, nomenon, God, passed by the Jural Society of the People. After the Civil War, they left it all to statutes by the attorneys. So it sits here and talks about this, and it says that this particular amendment, the one we know, was proposed in January 31st, 1865. Now, it goes down here in the bottom, and it says, a 13th Amendment depriving the United States citizenship any citizen who should accept any title, office, or emolument from a foreign power was proposed by Congress on May 1st, 1810, when it passed the House, having previously passed the Senate. It appears official in 2 Stat 613. It failed of adoption, being ratified by but 12 states up to December 10, 1812, then there being 18 in all. Now, you don't get to vote on an amendment if you were in a state. So they added in this Supreme Court annotation another state, because there were only 17 states when it was passed on May 10th, 1810. You don't get to go up until December 10th, 1812, okay, and say, oh, we're going to count this state that came into being after the ratification and allow it to retroactively be added to the list of 17, now 18. So that right there shows you that they totally are committing fraud and lying about the facts of the record, including in documents of the United States Supreme Court in 1938. So there's a lie in the public record, implying that states can be added and we can just add more. I mean, heck, you could say, well, only 13 of 50 have passed it as of 2016. That's not how it works. Whatever states, and according to, as I said, according to John Quincy Adams, there's only 17 states that were in the Union at the time of the ratification of the Tone Amendment. You don't get to add an 18th and have it open up until December 10th to 1812. Interesting how they say until 1812, huh? You know? So that puts it even further back. Instead of it being 14 of 17, now it's 14 of 18. You still wouldn't get it. So it says another, speaking of the second 13th Amendment, another 13th Amendment forbidding any future amendment that should empower Congress to interfere with the domestic institutions of the state was proposed on March 2nd, 1861, when it passed the Senate. It appears officially in 12 Stat 251. It failed adoption, being ratified by 3 states, Ohio, Illinois, and in a regular convention, because it was basically, we were in war. So it was never passed in that respect. But then they kind of put it back in there. It just changed it a little bit. Now, the significance of this particular 13th Amendment is that, one, it was passed right before the Civil War, okay, not a month, just a little over 30 days later. Now, mind you, as far as I'm aware, the second 13th Amendment passed in unanimity. Now, if all of the states agree that the federal government may not interfere, and this is before the Civil War, that the Congress shall not abolish or interfere with any state with the domestic institutions thereof, including that persons held to labor or service by the laws of the United States. That means slaves. So if all the federal instruments on March 2nd of 1861 agreed that the states can define slavery and peonage, how do, 30 days, see, March 2nd, the Civil War officially started on April 12th, 1861, which strangely enough, Lincoln, the traitor that he was inaugurated on March 4th, 1861. And then we have this on March 2nd, which is the last act of the president that was there. So the previous president, 2 days before inauguration, they passed this and Congress assembled, and then they bring in Kennedy, who's the knife dude for bringing in all of the foreign agents. So they all agreed on March 2nd, 1861, that the states could define slavery and peonage. And suddenly, amazingly, in April 12th, the next month, suddenly, perfectly down the middle, North and South, the United States is in a war about whether the states can define slavery or peonage. So how is it you pass a constitutional amendment with what I understand on this is a unanimous vote, and then 30 some odd days later, 40 days later, we're at war, and the federal Congress or the federal executive branch has called militia and is saying go to war and get rid of all these states that have slavery. That makes absolutely no sense. So you have to look at the facts of what happened versus the actions. And the fact is, all the federal instruments agreed that the states could do this, and then suddenly now they want to attack the states. And it has to do with money. It doesn't have anything to do with slavery. That's what that shows you, that the Civil War had nothing to do with slavery. That was a false flag. It had nothing to do with slavery because they all agreed. All the federal agents, all of our federal representatives said the states can define slavery and peonage. And they even ratify afterwards. I mean, the Civil War is supposed to be about slavery. Well, after slavery, after the Civil War, all you have to do is become convicted of a crime, and you're a slave and a peon to the states. So what did that solve? Most people don't understand. The 13th Amendment, it says you're a slave and a peon if you commit a crime. Have you ever gotten a traffic ticket? Because that's a crime. So people don't understand that the Civil War had nothing to do with slavery. It was a false flag event to rout out and to steal the joint stock trust companies of the states, who they had stolen money from. Millions of dollars they had stolen money from. Now, the significance of that 13th Amendment is it's, in my opinion, an implied trust, because they're separating the states from the federal instrument, saying that the federal instrument may not make laws governing peonage. Well, that is utterly unconstitutional, because according to the Constitution, all men are equal, due process, yada, yada, yada. Well, if you say that and you say, oh, the states can do what they want when it comes to slaves and peons, and you say, oh, the federal government can't interfere with that, then what you've done is you've separated the states from the federal instrument that says all men are equal and due process, etc., etc. But the issue was those pertained in their mind to just white men. They did not perceive that black people, women, children were equal. Now, the founders did, but the way they were running the government at the time, only white men got to have it, right? So there in their mind, in fact, there's some case law. Well, when only white men are running the government, of course, that's how they're going to interpret it. We're above everybody. This is how we are. So they sat there and said, we're going to separate the states from the federal government and say that the federal government can't interfere with slavery and peonage. Again, that's abhorrent and repugnant to the Constitution, as the states have to comply with the organic instruments that say all men are equal. And if you are creating peons, people are no longer equal. If you're creating slaves by criminality or tagging them as criminals, you're no longer equal, because you're creating two classes of people. You're creating the peons and the slaves, and then you're creating the people who make you a peon and a slave. The state of men who criminalize your activities, who engage you in ultra-virus contracts and peonize you against your will and your knowledge. So that, in my opinion, that amendment created what I would consider a trust agreement, an implied trust. Okay. Now, an implied trust is where you set aside It's not a true trust because you aren't necessarily at that point in time conveying any or bringing any material interest to it. But when you say we're going to separate the states and the feds from interfering, for the federal government from interfering with peonage and slavery in the states, that's actually an unconstitutional construct. And it's about commerce, because peonage and slavery is all about who can make money from the labors of other people. So it's a commercial trust. It's a commercial pact where the states had agreed to create a trust themselves to have this argument about slavery and peonage. And the situation with that is, though, if it is a trust, what this tells you, there's a couple things. It's the point of it being an implied trust is, I believe it's a parole trust agreement. And it says here, where a trust is sought to be enforced on the grounds of fraud, because we're talking about fraud. This is from Trust Implied by Law. These are all books I have. This is Treaties on the Constructions and Statutes of Fraud as enforced in England and the United States, with appendix. This was published in 1863. The author is Costin Brown, Browne, Esquire, Counselor at Law. Okay, the second edition. But he talks about that it's a parole trust agreement if the failure, it cannot be considered as inferentially stated by alleging the parole trust agreement and the failure to execute it. So you create a trust. If you create a trust in secrecy and then hide its instruments, that's a parole trust, because parole is when you do it outside. It's in hearsay. It's not necessarily on the record. It's a hearsay trust. So it's an implied trust. An implied trust is when you say, hey, we're going to do this, but you don't tell everybody you're going to do it. That's a parole trust, okay? It's a parole trust agreement. And it says that it has to be consistent with the principles of equity. It says, it seems to have been held that where in the case of trust arising upon agency, the defendant's answers denied the fact to agency, parole evidence was inadmissible to prove it. So in trust agreements, parole evidence is not allowed. Okay? That's what that says. In fact, and here's why. Here's in the Treaties of Equity. Okay, this is another book I own, Treaties of Equity, with the addition of marginal references and notes by John Fonblanc, Esquire, Barrister at Law. This was published in 1835. And this talks about, this is in section 4, what's page 648. At the very footnote down here, it's a G. And I'll read you the paragraph first. That it is to be considered thereof as it stands upon the will alone, and would have been even before the making of the statutes and frauds of perjuries, for before the statutes of will, by which men are enabled to make wills and devise their lands, it must be will in writing, and should parole proof be admitted, it would introduce a mighty uncertain and indefinite inconvenience. And here's why, annotated. G. Parole evidence is under some circumstances admissible to convert a litigee into a trustee. Okay. So if I bring forth an implied trust, if the states brought forth an implied trust in parole, what they're trying to do is make themselves trustee of the defrauded instrument. Okay. I always look at this, which would be the federal stock company. I always look at this and try to find a way in which these esquires were trying to preserve the instruments of our government. I don't, even though it is a coup, it is a coup with an intent to help law evolve. Because as I've said earlier, we created a concept of government that we didn't have the statutes and the law under our bellies to run. And so, in my opinion, and this is just me because I try to operate in grace, I believe that the esquire set aside the states with that first 13th Amendment, and even in the subsequent, the 13th Amendment we know. But they set up in statutes an implied trust with parole evidence so that they could convert themselves from the litigee, the person being held to the debt, into the trustee. Okay. So now, the significance of that, though, is that if we find out that they operated in fraud to defraud us, that according to law of evidence, This is the Practical Treatise on the Laws of Evidence. It is volume 2 by Thomas Starkie, Starkie, again an Esquire, 1828, published in Boston, where it says, when the fraud may be collected, down more. It has been held that the absolute transfer of personal chattels without a delivery of possession is not merely evidence of fraud, but actual void for fraud. Meaning, if you say you are the holder of the trust and you don't convey the lands properly, and you create the trust with the intent of defrauding as the trustee the owners of those lands, that trust is void. Not voidable, it's void. So all you have to do in the construct, all we have to do at this point in time in the constructs of law, pursuant to all these trusts we have over, we have the implied trust of 1776, we create a land trust. Then we have the 1812 treaty, which sets aside the United States citizen. Then you have the Tona Amendment, which established, the parsing of the law, common law, the fourth crown from all the other ones. Then you have the treaties thereafter. You have all these trusts. You have the implied trust of the states in the second 13th Amendment, and then the third 13th Amendment post-Civil War. So you have all these trusts, and they have to be trusts because they created conflicts in law, the greater law, that at the time they knew could be challenged, okay, in the law of equity. So all we have to do at this point in time is prove intent to defraud, or prove that we've been defrauded, that the trustees of our lands that are supposed to be managing our lands as public instruments or private instruments are stealing from us, and that have done these acts with the intent to defraud. And that's inequity. And if you prove that these people are intending to defraud you in equity of your lands, of your estates and chattels, of your jubilee, of the land trust that was set aside by the Constitution and its organic instrument, if you prove that these attorneys down the street, in the feds, in the state, wherever, bankers, are intending to defraud you of your jubilee that was set up by the original Constitution, that all men are equal and all men sojourn the land, and this global usufruct, all you have to do is prove that those people did any act in all this time with the intent to defraud you in a claim in equity, and that makes the trust void. And it means that the trust then has to be settled, and the people who were trustees have to come forth and prove how they didn't defraud you, and it has to be done with particularities. So I bring those up for those particular things. Now I'm going to show you how they intended to defraud you intentionally, because up until this point, right, all you know is that in 1840s, around there, they stole a whole bunch of money from the native tribe trusts. Okay, so let's go over some acts that occurred between or around just prior to the Civil War. And these are statutes at large, treaties, and proclamations of the United States of America from December 5th, 1859 to March 3rd, 1863. Now, that's a real small time frame. Usually it's a much greater time frame. But they were really busy obfuscating and undermining the instruments of the Constitution. And this is volume 12, published in Boston in 1863. It's edited by George Sanger. Again, counselor at law. So, P. Sanger, S-A-N-G-E-R. Okay. Now, this is Session 1, Chapter 24 to 25, 1861. This was an act, Chapter 25, June 29th, 1861. It says, an act to provide for the suppression of rebellion against the resistance to the laws of the United States, and to amend the act entitled an act to provide for calling the militia to execute laws of the Union. So the first thing, it statutizes the capacity of the president to call forth. Okay, it says right here that whenever, by reason of unlawful obstructions, combination, or assemblages of persons, or rebellions against the authority of the government of the United States, it shall become impractical in the judgment of the President of the United States to enforce by the ordinary course of judicial proceedings the laws of the United States within any state or territory of the United States, it shall be lawful for the President of the United States to call forth the militia of any of all the states of the Union and to employ such parties of the land and naval forces, yada, yada. So they statutize the capacity of the President to call for the federal militia, which is not in the Constitution as a construct. So you have the 13th Amendment creates an implied trust on March 2nd. The Civil War officially begins. Fort Sumter is attacked on April 12, 1861. July 29th, they call forth of 1861. Oh, there's one before that I wanted to get. No, it's weird. It's out of order. So July 29th, 1861, they say the president can call arms, right? So then in June, hold on, I want to get this here. So they statutize the capacity for a federal military to be called forth. So then we skip to June 7th, 1862. All right, now we're in the throes, they're in conflict, there's military going on. It says an act for the collection of direct taxes in insurrection districts within the United States and for other purposes. So here they statutize the capacity to tax the states and the land's insurrection. Okay, totally unconstitutional. So these are all statutory acts done by a coup federal instrument that had attorneys running around in it, stealing your money, acting against the law by the title of nobilities are not supposed to be there. So they do this act, right? Well, then here comes President Lincoln making a proclamation on June 1st, 1862, where it says that an act for collecting direct taxes in insurrection districts within the United States for purposes is made the duty of the President to declare on or before the first day of July the next following by his proclamation in what states and parts of the states insurrection exists. Now therefore it be known that I, Abraham Lincoln, President of the United States, do hereby declare and proclaim that the states, South Carolina, Florida, goes through the whole thing, are now in insurrection rebellion, and for reasons thereof the civil authority of the United States is obstructed, so that the provisions of an act to provide increased revenues for imports to pay the interest of the public debts that was created by the federal instrument by the stealing of millions of dollars by the private bar attorneys running the private treasury and the private bank for the Queen and the Pope. So they stole our treasury. They laid the debts onto the states who had already paid into those trusts. So the states were being levied twice. So the states were stolen from by the federal instruments. Then they come back and say they need to pay these debts because what happened after they found out that all this money had been stolen, instead of convicting people, they recreated a public instrument, a public treasury, and a public United States bank and put the debts in stock into them. So they just basically conveyed the debts of the theft and the trust accounts being stolen from into public debt. That's what they did in the coup Congress. And now they're trying to lay it onto the states. So again, as I'm going to show you, the Civil War was not about slavery. It was about the states being laden with debts that coup and foreign agents from embezzlement and just outright theft of the private treasury, privately run treasury, it was public money, and the private United States Bank, which is privately run, but public money, had stolen from the federal instruments. So he's sitting here talking about this. So he's sitting here saying, so not only that, he's saying they're in insurrection. So now not only can he collect debt, but he can call a militia, which he does. Again, federal militia, not a constitutional amendment. It's a statutory construct in coup. So again, all you have to do is prove that these people intended to defraud you and all their acts are void in trust law, which means everything after 1812 is void. Void, void. And so it's void as a lawful act, but that doesn't mean you can't come back and claim equity claims on the fraud for torts, trespasses, and all the offenses and the crimes against humanity and everything else these bar attorney people from the Queen and the Pope have exacted upon the people of this republic. Here's another one. An act regulating relating to habeas corpus and regulating judicial proceedings in certain cases. Okay, be it, and this is chapter LXX, so that's 81, and this is March 3rd, 1863. Mind you, this whole book is full of just sedition and treason and acts of utter lawlessness, which clearly is intended to undermine the sovereignty of the people, the states, their instruments, their hereditaments and chattels by foreign coup. Now, it'd be different if we'd been taken over because we owed money to someone that was lawful, and this was a lawful corporate coup of our joint stock trust companies. But it's not. This is by fraudulent instruments, fraudulent conveyances, lies, deceit, de facto treaties. I mean, all this stuff. This is not a normal what you would, if I have a company and I mishandle it, and I owe people money, that's one thing. But it's not like the Indians were suing us. This is foreign bar coup with fraudulent instruments and treason, sedition, and stealing of money. Millions of dollars theft in 1841. How much is $1 million in silver dollars in 1841 equivocally now? Okay, so what, one silver dollar is $28 now, so that's 28 million. Let's put it back into the how much a silver dollar would be, extrapolate to the value now from 1841. How many millions of dollars did they steal from the states and the native tribes? Okay, these attorneys in their little private coup instruments post 1812. So this is another thing they undermine. So I showed you how they undermine the Electoral College. Now I showed you how they, by statute, federal statute, in de facto, this is a de facto Congress. This is a coup federal Congress. This is not lawful. It's not got a grant of law. It's de facto. They are illegitimate. They're doing all these things. This is where they undermine another principle, habeas corpus, that during the present rebellion, the President of the United States, whenever in his judgment the public safety may require it, is authorized to suspend the privilege of writ of habeas corpus in any case throughout the United States or any part thereof. And whenever or wherever the said privilege shall be suspended, as aforementioned, no military or other officer shall be compelled to answer to any writ of habeas corpus to return the body of any person or persons detained by him by authority of the President. Now that's the military. It doesn't mean that if you're in civilian custody at this point in time that you can't be made to bring it back. In fact, you can tell the military to go tell the civilians to go get it. Okay? Go get it from the civilians because you're in the Lieber Code. But upon the certificate under oath of the officer having charge of anyone be detained, that such person is detained by him as a prisoner under authority of the President. And this has to do with people operating in sedition and rebellion against the coup federal authority. So basically gave the president, oh, we can just keep you as a prisoner of war, and we don't even have to answer to whether it's lawful. I'm just going to go tell my goons that I have unlawfully brought forth by federal statute and called the militia, though it's not a constitutional instrument, and I'm going to tell my de facto coup general, go steal you, and too bad, habeas is suspended. Getting that picture here? Because these are all things people don't remember because they don't study history and you're not being told it, and there's a reason for it. Now, here's another act. This is a very egregious act. Again, this is in the 37th Congress, Session 3, Chapter 82 to 85 of 1863. This was passed March 3rd, 1863. Right at, an act concerning letters, marquee, prizes, and prize goods. This is very important because letters of marquee, prizes, and prize goods. You're a prize. Anything that's taken in booty, of war, or maritime law is an instrument of prize. Being enacted by the Senate and House of Representatives of the United States of America in Congress assembled. Now I'm going to tell you, there's no way in hell that the United States in Congress assembled had the power to do this because it undermines the Constitution. So they're just putting that there because they want to pretend like they're de jure when they're not. That in all domestic and foreign wars, the President of the United States is authorized to issue to private armed vessels of the United States commissions or letters of marque and general prizal in such form as he shall think proper and under the seal of the United States. Notice, not the seal of the United States of America. Corporate seal. And make all needful rules and regulations for the government and conduct thereof, and for adjudication and disposal of the prizes and salvages made by such vessels. Provided that the authority conferred in this act shall cease and terminate at the end of 3 years by the passage of this act. Now, have you ever noticed that every 3 years they reaffirm some kind of war? War on drugs, war on crime, war on us. Okay, the reason why is because they have to re-up this statute in order to allow them through admiralty jurisdiction to capture you in prize and salvage. Okay? It's a very, very important act there. That's Chapter 85, passed March 3rd, 1863. Okay? Then it talks about 86, and passed March 3rd. An act further to regulate proceedings in prize and to amend various acts of Congress in relation thereof. So it says that whenever any prize property shall be condemned in any district or circuit court, or shall at any stage of the proceedings be found by the court to be perishable, or liable to deteriorate or depreciate, or whatever the cost of keeping, the same shall be disproportionate to its value, or whenever all the parties in interest who have appeared in the case shall agree thereof, it shall be the duty of the court to order a sale thereof, and no appeal shall operate to prevent the making or execution of such order. So again, where in the Constitution does it say that you can't appeal decisions from the district court? Again, expansions, people, expansions. These are slow, meticulous, well thought out, intent to defraud with malice federal acts that undermine the basic principles of our republic. And it was done in a coup Congress full of attorneys from Britain who had stolen millions of dollars from us and the states and were setting up, okay, to steal the wealth of the state stock companies, because that's what they're doing. They're going after the state stock companies now, the wealth of the states. There's more. And this particular act is egregious. It talks about admiralty law, and this is why they run an admiralty, because see, the 13th Amendment, the first titles of nobility, barred the attorneys from manipulating the law. So now they're manipulating the only thing they can operate in on the bar of equity, which is admiralty and maritime, and they're slowly, by statute, federal de facto illegitimate Congress statutes, undermining writs of marque are against the Constitution. So how do they think statutorily that he can issue writs of marque? It's specifically in the body of the Constitution. The writ of habeas corpus shall not be suspended is in the Judiciary Act of 1789. It's always being there for the inhabitants of this land. Okay, they're trying to tell, well, the inhabitants were British. No, all inhabitants, natives, everybody. Everybody has the capacity for the writ of habeas. Now, they're going to tell you that that's not the case. They'll make it up. And how federally now they're trying to say that children aren't covered by federal habeas statutes. Really? Now you know how they steal them. That's exactly how they steal them. That's what statutes are for, to exempt classes of people, to create different classes of people so that they can steal and extort from you. And that's what they're doing here. They have undermined in the federal statutes in a de facto coup Congress full of British subjects who took British titles of nobility, okay? They were undermining the general principles of our Constitution, and they are still doing it. But this is the origins, and this is the proof that they are fraudulent, they are foreign, and that all of their acts are void by law of equity. And that's where they're screwed. Okay, because law of equity is very clear. All you have to do is bring this forth. Throw this video on the bench, because this shows that they have undermined the principles of our founding documents, which they say they're operating over. Oh, we're the court of this United States. No, they're not. They're fraud. So this one is particularly bad, this Article 86. Here's another one. Again, all about extensions and expansions of the judicial power to operate in admiralty and to effect writs of marque, prize law on the land from a federal construct totally abhorrent to the Constitution. This is passed, again, March 3rd, 1863. March 3rd was a pretty busy day, apparently, for these coups, okay? This is chapter 90. An act to protect the liens upon vessels in certain cases for the purposes. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that in all cases now or hereafter pending with any ship, vessel, or other property shall be condemned in any proceeding by virtue of the acts mentioned above, and the annotation is Acts from July 13th, 1861, Chapter 3, and the Act 86, 1860, which I'm sure it includes us, which were recited in the title of the bills as reported. Okay, so when above mentioned, or of any other law on that subject, the court rendering judgment of condemnation shall, notwithstanding such condemnation, and before awarding such ship, vessel, or other property, or the proceedings thereof to the United States, they're going to award the vessels to the United States. So the United States in Congress assembled is creating legislation to convey property to the joint stock trust company. Okay? Get it? And the same people who are benefiting from these conveyances are also unlawfully in the Congress as attorneys. So they're giving themselves the power to unlawfully seize and convey property to their private joint stock trust company that they have unlawfully couped. Okay? Getting it? Or to any informer, first provide for the payment out of the proceeds of the ship, vessel, and other property, or any bona fide claims which shall be filled by any loyal citizen of the United States, or any foreign state or power at peace and amity with the United States. So they're even saying you can convey them in commerce to foreign corporations, people. Intervening in such proceedings, and which shall be duly established by evidence on a valid claim against such vessel or property under the laws of the United States or any loyal state thereof, provided that no such claim shall be allowed in any case where the claimant shall be knowingly participating in the illegal use of such ship, vessel, or other property. So, when you walk around with no soul, according to them, lost beyond the sea, reprobate, unresurrected in the flesh, you're using the vessel unlawfully. Are you getting the understanding here, people? These people have intentionally, okay, obfuscated the law and have gone about undermining by federal code statute the basic principles of our Constitution. And they are still operating under these because, remember, it wasn't restored. Lincoln wanted to restore the republic. No, it was reformed. So they're still operating with the foundations of these federal statutes, was undermined in coup. You have to think of this. It may not be where they shot you, but they used paper. This is a paper war, a banking war, a paper war against the will and the instruments, the lawful instruments of the American Republic. Okay, now, there's some other things happening here. This is the 28th Congress. Okay, I have one more in here, I think. Yeah, that's it. So now I'm to the 28th Congress. Okay. First session, chapter 99 through 100, and this is in volume 5, Public Statutes at Large of the United States, from the Organization of the Government, 1789 to March 3rd, 1845, edited by Richard Peters, Esquire, volume 5, 1848, Boston publisher. This is an act, I'm sorry, I think I may have already done this. The men's one. Yes, I did do that. Okay. Now, let's go to, I'm sorry, we're going to end this with the, go back to the 27th Congress, because there's two more acts in here I want to show you that undermine our sovereignty. And this is where they create and pledge the federal debt to the states. This is 37th Congress. And mind you, these are attorneys for acting on behalf of the Queen and the Pope, telling the states, you're going to pay these debts. Okay, this is a ludicrous historical construct. The fact that I can't believe that no one has ever made all these statements and I'm astounded that no one has ever done this. that I'm bringing this forth. I think it's just it just speaks to the propaganda and the way we are programmed today. So this is the 37th Congress, Session 3, Chapter 5658, 1863. This is page 665. This is actually an act. This is 5558, Chapter 58, an act to provide a national currency secured by a pledge of the United States stocks and to provide for the circulation and redemption thereof. Okay. And it says that there shall be established in the Treasury Department a separate bureau which shall be charged with the execution of this and all other laws that may be passed by Congress respecting the issuance and regulation of national currencies secured by United States bonds. So it's talking. It basically creates a public company. It affirms that we're going to issue bonds and that we're going to. Now this was passed on February 25th, 1863. Now within this document, Section 12 says, and be it further enacted that the shares of associations formed under this act shall be deemed personal property. This is important for everyone to remember because when they create these stocks, that's our personal property. And shall be transferable on the books of the association in such manner as may be prescribed in the bylaws of articles of association. So in the hidden laws of the United States Stock Company. And every person becoming a shareholder by such transfer shall, in portion to his shares, succeed to all the rights and liabilities of the prior holder of such shares. And no charge shall be made in the articles of association by which the rights, remedies, or security of the existing creditors of the association shall be impaired. For all debts contracted by such association for circulation, deposits, and otherwise, each shareholder shall be liable to the amount at their per value of shares held by him in addition to the amounts vested in each share. That section right there is where they made every one of the people of the United States liable for their foreign couped stolen debts. They say they're giving you stock and it's your personal property. And not only that, but they are transferable, okay, to succeed to all rights and liabilities of prior holders of such shares. That's a conveyance of blood debt. That's against the Constitution. So again, you don't need to look very far to find the intent to defraud in the federal statutes. They made it so that the president could summon an army unconstitutionally, could lay taxes on states for debts they didn't have unconstitutionally, could suspend habeas corpus unconstitutionally, could issue writs of reprisal on marquis unconstitutionally, that those prizes would be brought to the district courts and they were not appealable unconstitutionally, and that then they created joint stock trust company in the United States, creating public debt, and gave them to you and laid it and made it so that they could convey it after year after year after year, and how you conveyed it to your children, again unconstitutionally. That is a series of statutes that basically undermine, and not only that, but if he's sitting there quartering foreign troops in the states, that's posse comitatus. These are all specific acts by a foreign coup, a paper war of foreign bankers and their attorney servants to undermine the general principles of the United States, to steal our wealth and land and eat out the substance of the people. And they are still doing it. We have not restored the republic. It has been reformed. Reformed with the Pope, the Queen of England, and her attorneys running all of your corporate joint stock companies of the states and the trading company of the federal United States in coup. Okay? It's very important. And they also prevented you from picking a president. Now they had to come appoint him. Because guess what? After the Civil War, you never had a lawful election after that. The states were vacant. So the War of 1812, undermined the federal instrument of the lawful body. The Civil War, they vacated Sendai. All the federal instruments of law are vacated. The United States in Congress assembled doesn't even in de facto or de jure operate at this point in time. It's just a stock company who slid right in there under the name of the United States and started using all of our stuff in foreign coup. And then the Civil War vacated the states, Sendai. So they are not holding elections, people, and that's why tomorrow, your electors, which are appointed, will probably do whatever they're paid to do by whatever foreign coup that pays them to do it. Okay? Now, this is important. This is an appendix to the Congressional Globe. Let me pull out what this is. Volume 41, Part 1, First Session, 41st Congress, 1869. Okay? This is where they amend the judicial system of the United States. This is April 10th, 1869. Chapter 22, an act to amend the judicial system of the United States, being enacted by the Senate and the House of Representatives of the United States of America and Congress assembled. That the Supreme Court, and this is where they undermine the Supreme Court. Now, before there's some other acts where they make it 3, because most people understand that the Supreme Court was brought forth from the Congress. Okay? They would create a grand jury, and then they'd create a panel of judges, and they would pick judges. They would appoint judges from within the Congress. The Supreme Court was not an independent body. If you read the statutes from the 1840s to 1860s, you see where they remove it from the power of the Congress to bring forth the Supreme Court, because, again, this federal Congress would adjourn grand juries from within the bodies of the instruments of the people. And they would have hearings. And they would bring forth presentments. And then they would convict those people. And if it was of a common law nature in a federal case, they were there. So this is where they go from 3 to 8. Okay? It says that the Supreme Court of the United States shall hereafter consist of the Chief Justice of the United States and 8 associate justices, any 6 of whom shall be consistent of quorum. For the purposes of this act shall be appointed an additional associate justice of said court. So this is all by appointment. Okay? But in the common law, a judge can be appointed within the jury. The grand jury appoints the judge. Okay? That's what they do. The judge is not there. The grand jury creates the judge in common law. So this is where they're actually creating a statutory instrument, the Supreme Court, as we know it now, 8 judges. But if you go back, it was 3 at one time, and so they slowly create all this. But again, it's by appointment, where before, in the common law, judges aren't appointed. Judges are elected or selected by the grand jury. That's who appoints the judge in the common law. Not the president, not the Senate, not anybody. In the common law, a grand jury appoints the judge. Completely in contradistinction to the common law here. Another example. Now, this is the Laws of the United States, 41st Congress, 3rd Session. I believe it's the same. It may be the same. This is 1871. Excuse me. So this is the 3rd Session, 41st Congress, 1871, Volume 43, Part 3. And this is where they do an act to provide for the general government of the District of Columbia. And so it being enacted by the Senate and House of Representatives of the United States of America and Congress assembled, that all the party of the territories, that all that part of the territory of the United States included within the limits of the District of Columbia be, and the same is hereby created into a government by the name of District of Columbia, by which name it is hereby constituted a body corporate for municipal purposes, and may contract and be contracted with, sue and be sued, plead and be impleaded, have a seal, and exercise all other powers of a municipal corporation not inconsistent with the Constitution and laws of the United States. I notice it didn't say United States of America. Constitution of the United States. Totally different instrument than the Constitution of the United States of America. Constitution of the United States is a statutory instrument, not a law instrument, statute. So, it also says that the executive power and authority in and over said District of Columbia shall be vested in the governor, and who shall be appointed by the president. Okay, so this is where they incorporate the District of Columbia. which, in that is a municipal power, might be the way that they are using law, the coup statutes, to undermine the territories and extend the jurisdiction of the federal instruments into the states themselves. Now, I'm almost done here, but I wanted to bring you two things. We know that the 13th Amendment and the 14th Amendment were not lawfully ratified, but I wanted to show you where that is stated, and that's stated that the 14th Amendment was not lawfully ratified is actually in Congressional Record, and it's in the 90th Congress, Part 12, pages 15309 to 16558. Okay, it says the 90th Congress, First Session, June 12th, 1967 to June 20th, 1967. So June 12th to June 20th. So the 14th Amendment, equal protection law or tool of usurpation. Okay, that's what the point of it is, and it's a discussion in 1967, and this is after they've declared that there's not enough gold in the United States, Fort Knox, to pay for all the money outstanding, and basically have declared, by that statement, they declare all the counties, basically. Now they're into the counties. So they've got the feds, they got the states, and now they're into the counties. Because in 1966, you'll notice that most states had a court modernization acts, where they basically put the attorneys and the licensures of the right to practice law into constitutions, trying to monopolize the law in the counties, which is where we are right now. So the federal Congress has affirmed that the United States 13th and 14th Amendment were never lawfully ratified by a convention of states. 3/4 of it was never passed. And the significance of that is the 14th Amendment is an instrument of equity, in that it is a trust. Okay, and so they're using unlawful amendments that are de facto to create instruments of equity that they then, through the extensions of the admiralty and prize laws that I spoke to you about in the federal statutes, are holding you and conveying you, because they consider your body, though you have a trust, your body is the surety of it, even though you're the creditor and the beneficiary of that instrument according to the law, which I'll get after probably in the next part when I go into the Bankruptcy Act of 1898. Even though your body is what they're abrogating and subrogating, they're treating you as a commodity, as property to convey even to foreign states in what now would be treasury notes. They sell you, basically. And the other last thing that I want to bring up, well, there's two more things actually, is that in 1950, prior to this, there was a report during the Red Scare, a report on the National Lawyers Guild, legal bulwark of the Communist Party, where September 24th, 1950, a committee to the Committee of the Whole House of the State of the Union, in order to be printed, the 81st Congress Second Session, House Report number 3123, Union Calendar number 1078, said, and this is within the Committee of Un-American Activities, U.S. House of Representatives, it says that the National Lawyers Guild is part of the Communist Party, that it has consistently fought against nation, state, and local legislation. Okay, and that it actually is undermining the tenets of our nation. So they declare attorneys acting against the wealth of the nation. So I'm going to go in the next part. We'll go a little further, but I hope that kind of brings you to some facts of when you go to the voting poll tomorrow, what you're not doing, which is you're not voting for your government. You're voting for a coup Congress. So think of it that way. The one last thing I do want to talk to you about, because this has to do with Admiralty and Maritime, is the Benedict on Admiralty, because this is what our founding fathers really, really spoke to us about. And that is that the Constitution of the United States, this is subsection 19 of the Benedict on Admiralty. The Constitution of the United States grants the federal government jurisdictional power over all cases of admiralty and maritime. So when they cooed the federal instrument, they had, because that's the only jurisdiction they had sole entity of, they had to bring that admiralty and maritime instrument in. And then the next fourth and probably final section of this grouping of presentments, I'm going to talk about how they do that with specificity. So when you vote on Tuesday, know that you're not voting for nothing. You're voting, it's a pretend vote. It's a total farce. They had every intention of appointing who they want to appoint. And anybody who thinks otherwise clearly doesn't have any constructs of history or the understanding of the history of the coup of this nation. And know that you are 100% under the coup of a foreign instrument, the National Bar and the State Bar Associations, who are not operating on the behest of the people. They are operating in foreign coup to convey wealth and power to their masters that are not here. And that was the whole point of the 13th Amendment, because we knew, the Founding Fathers knew back then, that anybody who carried a bar card or was of a union construct was antithetical. And a union bar card holder, the constructs of that is antithetical to the American construct of common law and the American Republic. And in fact, is ultimately, if you think about it, a very fascist, communist machine built to rout out and eat the substance of the people, just like it says in the Declaration of Independence. So I leave you with that before the election day, and ruminate on it. I may not get the annotations done today for everything that I brought forth, but I will work on those. I'm very busy working on a case of a child that was stolen by the Coos State Bar of the state of Ohio, who have openly put upon the record that you may not bring forth a habeas now unless you are a bar licensed attorney. So think about that tomorrow and Tuesday when you're trying to decide whether you want to vote for an attorney who's clearly corrupt and potentially engaged in child trafficking, who helped write Child Protective Services, actually amended the Child Protective Services federal legislation to incentivize and give states money for the stealing of children. That's what Hillary Clinton did. So when you're sitting there, and I'm not voting, I don't vote. There's no such thing as a vote. It's a poll. I don't participate. I'm not designated as a United States citizen. It's a farce. But when you're sitting there going, you think you're going to poll, and they're going to take your poll. Do I want to poll for the attorney, or do I want to poll for a guy who's a business leader who was born and raised and has a vested interest in the capital of this nation? You might want to think about who you really are pulling for there, because voting for an attorney, that's an act of treason, just so you know. So have a good day, and hopefully I'll get the fourth and final series in here sometime in the next week. I apologize for the delay, but as I said, I'm trying to save a kid who has been squarely stolen by the state of Ohio, an utter violation of the Constitution and the federal statutes. So namaste to all of you. Have a very good day.